Welcome to the We Win Injury Law podcast. I'm Tyler Todd, your host, sitting with my co-host, Jaron, the Snow Canyon Man, Sandberg. Good afternoon.
Good afternoon.
Good afternoon, everybody. We're going to talk about and kind of break down, kind of give you a beginner's guide to personal injury law. And obviously this is passionate to us, is what we do every day. We're personal injury lawyers. You know, we've talked about famous cases. We've broken down Jurassic Park, Home Alone, Cardi B, Blake Lively, Ryan Reynolds, Baldoni. Wait, is something going on with that recently? Have you seen something recently about that? Like, I feel like something popped up recently.
I haven't seen anything, so I'll have to look.
I can't tell if it's AI or not. That it's just like, I think it's kind of simmered. We need to look into it because we need to kind of we need to do another podcast on
fans deserve a recap of
like
that
a little like update on everything. But today we want to talk about kind of some of the basics. It's hopefully it's not boring. It may seem boring, but this is tort law. Okay, so when we say personal injury lawyers or we're accident lawyers or injury lawyers, we really are trial lawyers, and it all stems from tort law. So when you go to law school, if you go to law school, or if anyone's interested in going to law school, and I hear this all the time, you probably hear it. I always wanted to go to law school. That was my first choice or my second choice. I wanted to go to law school. And sometimes I'm like, you should have done it. Or sometimes I'm like, good thing you avoided it.
That's like when people tell me, everyone when I was younger used to tell me I should be a lawyer. And you're like, that was adults saying in a nice way that you argue too much and you were a little shit.
Yeah, like, that's right.
They weren't complimenting you.
No.
You argue too much. You should be a lawyer.
You talk back too much. You were rude.
Yeah. You should be a lawyer. Which is funny because that's not what makes a good lawyer.
No. Well, or maybe it was just because, for me, I remember just push back, right?
Yeah.
Is that really how it works? Or is that right? Or is that okay? Just because you're my senior doesn't mean, but whatever.
But for all of those of you that are listening, that you did think about being a lawyer, we're not making fun of you.
No, we're not.
It's the other people.
It's everybody else.
It's everyone else.
But it all stems from tort law. What we do on a daily basis is tort law, and we take torts when we're in law school. Every first year law student around the country takes tort law. And in tort law, you learn about accidents and injuries, and not it's anytime anyone's been injured by the negligence of another or entity, so corporations, businesses, individuals, and then how does that look like, and how, what are the duties of individuals or entities to each other, what are the damages, what that means in the law. And when I think of torts, I think of John Grisham. Do you read John Grisham?
No, I have a hard time with like lawyer shows, lawyer books.
I actually think John Grisham is like legit.
Were you into him though before you went to law school, or is this always like post?
I think so.
Because I wasn't into him. I think my dad reads a bunch of John Grisham, but I've never. I like the movies. Like the movies they've done.
The movies are good, right?
Yeah, all the movies are great.
What's your favorite John Grisham movie?
The one that always comes to mind is the jury duty one.
Yeah, jury duty. That's a good one.
I thought that was great.
With Cusack?
John Cusack. He was good in it. Just clever.
What's the...
Was John Grisham a lawyer? Is that his background, or just really like the law?
I think he did go to law school, if I recall correctly. I think he is.
Okay. Because obviously a lot of books,
I don't know. Is John Grisham a lawyer? Let's look. I think he is, or at least I went to law school because his books are on point. It's not like watching Suits and you're like this is not like real life.
Yeah, I can't imagine like a detective loves watching like Brooklyn Nine-Nine and thinks this is accurate.
Grisham's a lawyer.
Yeah.
So
comes from a space of he knows.
Most of his books are about kind of like small town law, or solo or like a small like law practice. So it's fairly like spot on.
Is Lincoln lawyer John Grisham, or is that?
I don't think so.
I don't think that was. Anyways, that's if there's one series I can get behind. I do like
Runaway
the legal
Jury. I think that's what you're talking about.
Yeah.
With Cusack.
That's the one. That's the one I'm most familiar with.
Yeah, Runaway Jury, The Firm with Tom Cruise, The Pelican Brief with Julia Roberts. What are some other good classics with him? His books are great.
Michael Connelly is who does Lincoln Lawyer.
Okay, Michael Connelly.
Also good.
But Grisham's book, I think they're great. One, because there is some like twists and turns to him. But he wrote a book called The King of Torts, and that is a great book. It kind of talks about a small town lawyer that kind of gets into the when you hear the phrase king of torts or class action lawsuit, most people are familiar with class action lawsuits. Okay.
Yeah.
And because most people have gotten or seen the ads of like Johnson & Johnson baby powder.
If you have mesothelioma.
Or what's the asbestos?
Asbestos.
Right?
Roundup.
Roundup. I mean, all those things. So most people are familiar with class action lawsuits. Yeah. And that is a tort. That is a type of tort. So with class action lawsuits and then The King of Torts, this book by Grisham, it's actually a really good read. So if you're interested, it's just interesting to see all the types of tort that are out there and that we do. It's not just car accidents. Yeah. And I think that's what I want people to understand. When you're talking about personal injury law, it's not just car accident. We're not car accident lawyers. We're tort lawyers or trial lawyers. And so we represent people that have been injured when there's been a wrong or negligence by another or entity that's caused harm to a person or entity. Yeah. So that is at the very sense tort law.
Yeah. And I think we break it down into kind of the four elements, right? That's, the first things you learn in law school when you're studying torts is you're learning kind of the duty, breach, causation, and damages.
Right.
And you spend a lot of time on each of, I want to say it was like a couple of weeks on each of those elements because they translate into every type of civil case that we do, or at least almost every civil case. There's some that have more. There's, fraud cases and some things where there's some more elements than the basic of negligence. But all of it kind of stems from duty, breach, causation, and damages. What was the duty? Was that, and that's normally, pretty simple standard. What would a reasonable person do in that situation? Breach really just means did they then not do what was reasonable in that situation? And then, gosh, I feel like we spent maybe a month on causation because that can get so complicated.
Causation's huge.
And I have a really hard time explaining that sometimes to people because we study it. So, it takes months in law school, and then me and you, we deal with it in motions and we deal with it in, cases we deal with. It is sometimes hard for people to realize, like, they just focus on one of the issues. Gosh, I'm so hurt.
Right.
And I'm like, okay, but the person that you're saying did the wrong didn't have a duty in this situation. And so
you weren't supposed to be there.
Yeah, you're a trespasser.
Right.
We had a case, you spent, 18 months maybe on that case that a judge dismissed it. And it was all based on that because our client got labeled as a trespasser. And really, it was her sister that her testimony was terrible for, but got labeled as a trespasser, and it killed the whole case because then the duty shifted, or what the duty you owed to a trespasser was different than what you owed to someone else on a property, and it killed the case. And so
our name is We Win Injury Law, and that is but we did lose this one. Well, we feel like we're pretty out of it and try to do everything we can to win, but in this one we lost.
Well, and I want to be clear that like this was a case that the client initially, when she called, and I remember this conversation with you, I did the intake with her, and it was a unique enough case. There was not case law really on point that we knew it was kind of going to be a little bit of a first impression. But I remember your words to me that day one was, depending on how the judge labels this client is how this whole case is going to go. And we had some opportunities to settle that case. The client
they'd offered some money.
The client did not want to settle that case, and so there were some nuances to that case to where the client was kind of all in. The client was an all or nothing kind of situation, and there's cases we've had where those kind of questions, we have opportunities to settle. And so in this one, even though it's a loss, day one, we knew this was the issue.
It was a hard case.
Day one, we had told the client that. So I don't want to call it a loss.
It was a zip line case.
We got shocked at trial or something.
Right.
This
It was a zip line case where our client was trespassing, technically, onto another individual's property who had a zip line who was not there.
Yeah.
And she got on the zip line and was significantly injured, and the court labeled her a trespasser.
Yeah.
So then it kind of goes back to this duty thing we were talking about, that the court found that the homeowners, landowners, property owners did not have a duty to our client to protect or to warn.
Basically to make the zip line safe in any way.
Yeah, and to potentially, protect her from injury, and she was injured.
Yeah, pretty catastrophic injuries.
But the court found because she was a trespasser, there was no duty. So even though we had causation, we had damage, we didn't have duty because of the labeling that the court labeled her as a trespasser.
Yeah, and this one, her version of events versus what her sister told us too
We're a little different.
We're very different. So when we got to her sister's deposition, that really shifted the case in a big way as well.
Yeah, the sister did not help at all. Which I still kind of find a little crazy.
It was just, I think the sister, and this goes back to we can't prep non-clients, but I think the sister was somehow worried that if she didn't throw her own sister under the bus, she was going to somehow be on the hook for something.
Well, and it goes to hopefully your credit, our credit. We're not going to call the sister and be like, "Hey, say this."
No, and that was where what she had told us, what our client had told us versus what the sister had told us was so different.
Had the sister said, "Yeah, the homeowner gave us permission,"
which is what our client had been telling us from the get-go,
it would have been a totally different case.
But then when we got
to the sister was like, "No, we didn't have permission."
No, in fact, I told her not to get on it.
I told her not to do it, and we were like,
you have those moments where you just. But again, it goes back to exactly what you said. Is so to prove negligence, we have to have all four. We can't just have damages or major injuries, or even we even had almost the breach element of this was a really faulty zip line, had been jerry-rigged from an Amazon kit. They had taken away the safety features.
No, I think they were actually proud of the homeowners, because we deposed the homeowners. I think they were actually pretty proud of how good it was, but they had taken away
the padding
because they were not there. It was during the off season or something, so they just weren't there and hadn't used it. So yeah, they had taken away the padding and some of the things to make it safe, right, or safer.
But yeah, that sister throwing her under the bus didn't help. So
that's funny.
I just and again, this is what was hard is we had opportunities to settle, but it was low. They were low offers, and so I can completely understand where the client was like, look, it's such a low offer, it didn't really justify hey, it's worth the risk. Let's go see what the judge does. And in this one, the judge, I think, based a lot on what the sister said, because the homeowner was going to say what was self-serving to the homeowner.
Sure. And
our client, to some degree, again, depending on whether you believe the sister or our client, I think our client really did believe that she had permission to be there based on what the sister had represented and some other things. And then the sister's testimony just derailed that case.
It didn't help, yeah. And that's why everyone, if you're listening, it's so important to have maybe independent witnesses or people that know you but maybe don't have really, nothing to gain from it, to have character witnesses or people that can kind of substantiate what you're saying or what you've been through or what you're going through, because an affidavit, that's when you sign a sworn statement, are always kind of self-serving in nature. And so it doesn't always have the oomph or the power or the authority that you think that it has. And so people are like, I'll sign a statement, and I'm like, okay, that's great, but it is your own statement. And it also always, and the courts and the judges look at this, has some degree of, it's a little bit self-serving.
Yeah.
So witness statements are so important. So as we talk about this, I just want to maybe throw it out there. If you're in an accident or you're hurt in any way, it's so important to either for you to do it if you can, or family members to get some objective witness statements from people that don't have any dog in don't have a dog in the fight to get their perspective, because that goes a long way.
And that's even important in accident scenes. If someone comes up and renders aid, if you can remember, like, hey, what's your contact information? Who are you?
Yeah.
Because sometimes it's like, oh yeah, people came up and helped me, but then the police report doesn't have any witness names. They obviously don't remember the person's name, and so yeah, witnesses are helpful in almost every situation of your case. But going back to just again, duty, pretty straightforward. Is did this person have a duty to drive in a reasonable way or to make their premises safe, right? We deal with that a lot. And then breach is they didn't. I feel like breach was probably the easier of
breach
the
is the easiest.
If you've established the duty, breach is normally pretty obvious. Then that causation element, is where like law school exams are. The bar exam loves to trick you on is because causation can get really, really tricky on, are your injuries a result of that breach? And we deal with this even with pre-existing conditions and aggravations to injuries. And there's a lot of different things that come into play on, did this accident cause those injuries? In fact, we deal with medical doctors on, hey, your report mentioned something else. Was it related to the accident or was it not related to the accident? And those are all things that we're trying to establish for that kind of causation element. And even, we don't need to necessarily get into it, but there's, causation's technically kind of two different elements within there, and I don't know if we want to get into it, but it's just such a nuanced issue that clients sometimes have a really hard time.
Well, law school students, everybody, we come out of that 1 year of tort law and you talk about causation and you're still scratching your head. That's why the bar exam does it. And then we fight over it every day with opposing lawyers. And the best way of talking about causation, for example, is let's say you get in a car accident and you break your leg and it needs to be reset, right?
Yeah.
Broken leg, no big deal, not life-threatening. But if you go into surgery and there's a complication or the doctor nicks like an artery and you start bleeding out, did the accident proximately cause your bleed out?
Yeah. Because if you wouldn't have been in the accident, you wouldn't have broken the leg, you wouldn't be in surgery.
So, and then they're going to argue, yeah, but we didn't cause the bleed out.
Yeah.
We just caused the broken leg. So that kind of goes to the issue of direct causation and proximate causation, which that's why we have jobs.
Yeah. It is complicated. And I think people just have the hardest, like I've got a client right now, she's older and she's had a really hard time grasping that concept because she had a really nasty fall in Las Vegas approximately 10 years ago, really hurt her back. And a lot of documented, went to the doctor, has done a lot of treatment related to that back injury. Now we have a new accident. She's in an accident, truck goes off the road, she's a passenger, and it's really reset her back to square one, but square one of how she felt with her previous injury. And so I've really had to work with her on understanding that the aggravation of a previous injury, while we can compensate that, is not worth as much as if this has been a brand new injury.
Correct.
And that we're going to get a lot more pushback from the insurance company because of a pre-existing injury, as opposed to if this is just a fresh, brand new injury as a result of the accident. And that's hard to understand for lawyers even.
Right.
It's defense counsel and us argue about it. And so, we try to do our best to explain it to clients, but there's some clients that just still have just the hardest time grasping that concept.
We need to know. If there's previous injuries, we need to know or previous accidents or slip and falls or workers' compensation claims that have been made in the past. We need to know that information because insurance companies inevitably, in every case, will try to argue that causation issue. Yes, we accept responsibility for this particular accident or fall or whatever caused this particular injury. Insurance companies will say, yeah, we take accountability, we take responsibility for that. We didn't cause that particular injury. Yeah. They had that, or that came from that, or it came from this. That's how they wiggle out of paying you what you really deserve, because they either fight in one of two ways. Either there's no breach, we didn't have a duty.
Yeah, we didn't have a duty to even.
So we're not at fault.
She's a trespasser.
So either one, we're not at fault, or two, okay, yeah, we're at fault for that, but we didn't cause all the things that you're complaining about.
Yeah. And how many times have we been in a situation where the adjuster calls? We've already had that conversation with our client about, hey, have you been in any previous work comp injuries? Have you had any previous accidents? And the first thing the adjuster says is like, what about this 2017 accident? And you're like,
and you
did
guys,
my client
they know.
not tell us? Like,
They know. They have databases. All the insurance companies have databases of claims that have been filed in the past. So they know. So
if there's anyone not to hide it from, it's your lawyer.
it's from us. Because we definitely don't. We do not want to be like.
Doesn't happen often. Most of our clients are really good about telling us. But
they're like, what about that one in 2017? What are you talking about? Oh, that one.
Yeah.
That was nothing.
Yeah. And they always
They
say,
weren't hurt.
every time a client says, like, and you're like, did you do any treatment? Just like a little bit. And as we get into it, it's always more.
Did you file a claim? Well, I did. Did you get any money? Well, maybe just a little.
Yeah. It always is like, it just is. It's one of those things that, like, again, telling your lawyer the full story, especially when we ask, like, what's happened, what's the history, and we get into it. It's just the worst thing to. You never want to have. And again, it's, and we've discussed this. The value of your case. The value of your case with pre-existing injuries is still high. It's just maybe, again, there's going to be some discount for the injury already existed, but it's still good. But the value of your case, if you try to hide it and look like a liar,
Makes it a little worse.
makes it worse.
Yeah.
And it just makes it harder to negotiate that, because then, we haven't been able to flesh that out with doctors. We haven't been able to get medical records to say this is what was related to the previous accident versus this was what was related to this accident.
Everything we're doing it with the expectation that we're going to go to trial. So that's why I said at the start of the podcast, we're really trial lawyers, because, when we put our lawyer hats on, that's what we're saying. Okay, insurance company, we believe there is a duty. There's been a breach of that duty. There's causation of damage, which are injuries or loss of income or permanent, brain injuries or whatever it may be. Yeah. So there's damages. There's pain and suffering. Everybody knows that phrase, pain and suffering. Those are damages in our world. So we tell the insurance company we have met all the elements of this tort. Yeah. If you don't pay what we think is fair value and reasonable value, then we'll take this to trial.
Yeah.
Now, value is dependent on the damages, the injuries, loss of income. It's also dependent on the venue. When I say venue, people are like, what's that mean? Well, where we have to file your lawsuit.
Yeah.
Okay? So if we have to file your lawsuit, if you live in a very conservative jurisdiction, state, county, city, then the people that are going to come listen to your case are probably very conservative. So you're going to have a very conservative jury. If you live in a Democratic state, more liberal county, city, state, then the likelihood that your jury members are going to be more Democratic, more liberal. And all that's relevant to determining case value. Now, more conservative, typically the trend is conservative, lesser value, more liberal, higher value. There's, varying degrees of opinions across the country that's changing. So,
well, and I like this, me and you have sat in a deposition, or not a deposition, mediation recently, where I don't know if you recall, we were working actually with a client's father, because the client was in, pretty bad shape from the accident. And he walked in saying, this is $1 million case, and anything that's either not $1 million or just shy of it is unreasonable. And there was a lot of things in that case that made it not worth $1 million case. And we had to have a lot of conversations with him about just what's the value to your son? Yeah, it is $1 million or more than that. There's no amount of money that's ever going to make him whole. But what's the legal value, right?
Right.
When we're taking into consideration what a jury's going to see, the venue of where your jury's going to see this case, the issues that this particular individual had that were going to come out at trial. There was no way it wasn't. Really diminished the case value. And there was a lot of factors that went into that by the end of it, and the case still settled for a lot of money, so it was, well past six figures, but it wasn't $1 million. And I just remember how grateful the client was for that explanation, but it maybe took 4 hours of describing legal value versus actual value. And I know that sounds like a long time, but it really is just it's really hard concept to grasp.
Well, unfortunately, there are people or clients that we do not want to put in front of a jury.
Yeah.
And I say that in such a way that we believe and we want to treat all of our clients and advocate. We want to win in everything we do, trust me.
Yeah.
But there also is a practicality and a reality to some cases, like this particular individual, that if you put a certain person in front of a jury, because there's times where, I mean, you meet someone, you might like them instantly or you might dislike them instantly.
Yeah.
Just the way they are, the way they appear, the way they talk, and every juror has a bias.
Yeah.
So there's been times where we're like, if I don't like my client, and we have had clients where we just don't, not that we're not fighting for them, we just don't like them.
They'd just be hard individuals.
Because they're just hard individuals, and they call our offices, and they're rude, and they're mean, and that happens.
We're thinking the entire case, how do we triage this client? Can we get them to a point where people are going to understand the story and disregard how they act?
Right, because you put that particular person in front of a jury, and the jury will more than likely not like them.
Yeah.
And if they don't like you, they're not going to give you money. And in our world, justice is money. So
it seems like, too, these particular clients are always the ones, too, that tell you that people really like them.
yeah.
Have you ever noticed that? It seems like that's a common phrase. They'll say something like, people tell me I'm charismatic.
And that their case is worth $1 million.
I'm like, was that like your HR representative trying to like say it in a nice way?
Who's telling you this?
Before they give you like your write-up?
That's like your aunt and uncle. They're like, you need to be a lawyer.
Yeah. It's just these particular clients. And so in this way, it's not that this client wasn't likable. And I, we like all our clients to some extent. There's some difficult clients.
Maybe better than others.
But the reality is those things do factor into your case value.
Yeah, and that, whether I like you or not doesn't have any impact on whether we're fighting to get maximum value from the insurance company.
Yeah.
But it does impact whether and where the venue is, the jurisdiction, the cases, the past history. All those things have a legal value determination on where do we take this case.
Yeah. And so even if we've proved all of our elements, we still have those factors of, what's your casework? And there's not, juries don't have a cookie cutter. Oh, you have 10,000 in bills. So we'll use a calculator, times that by 4. Here's what your case is worth. It's just not that easy.
And you just never really know what a jury's going to do or what they're going to like or dislike. For example, there was a mediator we use, and he always tells a story. He had a trial where he thought he had a great case and a very likable client, but the jury, I don't remember if it was like no cause, meaning they got zero money, or very little money, like very little money. And so he polled the jurors after the trial and said, hey, what happened? And they just didn't believe apparently his client because, they were alleging, significant back injury, but she showed up every day in trial in heels.
Oh yeah, I do remember that. Yeah.
And so the jurors were like, she really can't be that hurt if she's walking in high heels.
Yeah.
And they just didn't like the fact that she was wearing high heels, so they didn't put credibility to the severity of her back injury.
Well, and I think we know, like, I remember I studied this book, and I had this old seasoned trial attorney in law school that, we bought this book that was like $800, and of course he didn't renew it for next year, so it didn't resell. But it was called Jury Dynamics, and I remember like the first chapter of the book going off on, they've done these studies where they tell people, hey, the court is so backed up, we're doing jury trials at this office building. They make people think this is a real jury trial, and they get selected, and the attorneys present their case, and it's really just a way to they're wanting to basically record what happens in jury rooms.
Right.
Which I just remember being so oh crap. They talked about, the number one thing they talked about was how the attorney's dressed, and I remember being like, that shouldn't have anything to do with it, but it does.
Right.
And then the very next thing they always discuss is everything that the judge told them not to consider as part of the verdict. I remember being Okay, that's very unfortunate. And then it was those things. It was all the things that had nothing to do with the evidence that was
Or the
presented.
facts, or yeah.
It was, did you see how the juror, how the plaintiff walked into the case? I don't know. He looked pretty bad, or vice versa. And so that when you tell that story, and I think I know the same mediator, because I think he said it in a recent mediation fight as well, or I was in on the one that we did together. You don't think of those things sometimes, and the high heels shouldn't matter.
It shouldn't matter, but apparently to the jurors it did. And it just went to credibility, right? Not that they were like hated that particular high heel or didn't like the person.
And I'm sure the attorney had told the client, like, hey, dress nice.
Dress nice.
You want the jurors to know that you take this seriously, and dress professionally.
Sunday best.
Sunday best,
and that's to her. Sunday best was a dress and high heels. So you just never know, and so that you're always trying to look at the perspective of, okay, what's the jury going to do, and then that's when we resolve cases pre-litigation, you're considering all those factors. Yeah. So that's kind of the nuts and bolts. I mean, we can spend hours on.
Yeah.
I mean, we spend a year on it in tort law, in law school. So, and we still leave law school thinking like, what the heck is that?
Yeah.
If you really want to know and have questions, go read a John Grisham book. He's actually pretty good. So, and they're fun reads. So, if you have questions, you don't know whether you have a case, reach out to us. You can find us online, wewinagelaw.com. Go to our website. We have a chat. You can engage with us. The consultations are always free. You're going to see now that we're partners, official partners with RSL, Major League Soccer, Real Salt Lake, which is super exciting. We're also official partners of the Salt Lake Bees, AAA baseball team. So awesome organizations that we're partners with, which is super exciting. So if you're in Utah and you feel like, do I have a case? Do I not have a case? Reach out to us. The consultations are always free. And we know this. We look at it from the angle of, trial lawyers.
Yeah.
And what's this going to look like in order to make sure that we win for you? And that's everything we're trying to do, is to win for our clients. So whether we like you or not, we're going to do everything we can to win for you. I assure you that. So be safe, everybody. Leave early, slow down, subscribe, share, like, please, to our podcast. We appreciate you guys tuning in. Until next time, everybody, be safe, leave early, slow down.